Hello viewers, welcome to our YouTube channel of the Judicial Service Commission, Uganda. My name is David Wandera and I'm a legal officer under the Directorate of Legal Education, Public Affairs and Research. So like we have said in our previous videos, one of the core mandates or functions of the Judicial Service Commission is to prepare and implement programs for education of the public on the law and administration of justice. Before I go to today's video, I just want to let you know that we have several other videos that we have already made on the JELOS. We have made videos on money lending, so you can also, after this, go and have yourselves look at those videos. So for this video, we are going to be discussing alternative dispute resolution. Alternative dispute resolution is sometimes referred to as ADR. It's merely a short form for alternative dispute resolution. So alternative dispute resolution is a combination of several mechanisms through which disputes can be resolved without necessarily referring to the formal court processes. So a dispute can actually be resolved without you going to court. The types of ADR are mediation, negotiation, conciliation, early neutral evaluation, and several others. ADR has been in Uganda and even in the world all over since time immemorial. One would wonder, before Europeans introduced schools and courts of law, how were people resolving their disputes? So there are still community before the Europeans came. People in those communities still had disputes which arose amongst them. These disputes used to be taken to the elders in the communities. They used to be taken to the clan chiefs or any other people who were knowledgeable by then and respected in the communities. And these people would issue decisions concerning those disputes which were binding on those people and which would be respected. Those were also means of alternative dispute resolutions. The ones that I've mentioned are merely formal ones, but the process is the same and the resolutions are usually the same. So in Uganda, there are several laws that actually provide for and govern alternative dispute resolution as a means of resolving disputes. So someone does not have to say, okay, you're talking about alternative dispute resolution, and yet the laws in Uganda say we are supposed to go to court. No, even the laws in Uganda encourage people to use alternative dispute resolution mechanisms as means of resolving their disputes. Some of those laws include the Constitution of the Republic of Uganda, the Magistrates Court Act, the Civil Procedure Act, the Civil Procedure Rules, the Arbitration and Conciliation Act, the Judicial Mediation Rules, and among several other laws which actually encourage people to resolve disputes by using alternative dispute resolution mechanisms. So who can be a mediator in case a dispute arose between certain parties and they want to have it resolved through mediation? A mediator can be anyone that the parties have confidence and trust in. So mediation can be court annexed or it may not be court annexed. A dispute may arise between the parties and the parties themselves decide that, okay, this dispute has arisen, but we can take it to a parent maybe to resolve it. We can take it to a clan leader to resolve it for us. We can take it to an elder in the community to resolve it for us. We can take it to a religious leader, say, to resolve it for us. So any of those people who the parties have trust and confidence in can resolve a dispute through mediation. However, in court-accredited or court-annexed mediation, the mediation has to be conducted by a specific category of people who are mentioned in our Judicial Mediation Rules. Those people are it could be the judge in the court, it could be the registrar, it could be the magistrate, it could be a court-accredited mediator, or someone who has been accredited by the Center for Arbitration and Dispute Resolution in Uganda to be a mediator in such circumstances. But the parties themselves, even in court-accredited mediation or court-annexed mediation, can even choose a person to be their mediator, someone who they trust and has the qualifications and competencies. Mediation has several features that make it very unique. And in my discussion of these features, you're going to actually get confidence in why and more reason as to why you should consider mediation and alternative dispute resolution as a way of resolving the disputes which may arise out there. One of the features of mediation is that it's voluntary. So there cannot be mediation if the parties are not willing to conduct a mediation. For there to be a mediation, both parties have to agree without any coercion from anyone that they want their dispute to be resolved through mediation. The other feature is that it's facilitated by a neutral third party. So for there to be a mediation, there has to be someone in between these two disputing parties. This neutral third party helps to facilitate communication between these two parties to see that at the end of the day, the two parties reach an amicable resolution of that dispute that may have arisen. The other feature is that it's confidential. Mediation is confidential in a way that it's conducted between this neutral third party and the disputing parties only. No one can come from outside to listen to what is happening in the mediation room. So you realize that as compared to other court processes, the formal court procedures, in mediation it will only be the mediator and the two disputing parties, and they will reach a resolution to their dispute. The other feature about mediation is control. In mediation, the parties have control over the process in that the parties themselves come up with a solution to their dispute. It's not the neutral third party who finds a solution for the parties. The neutral third party merely facilitates, but then the solution that the parties reach is what is taken as the decision. The parties themselves come up with a decision for that dispute. So those are some of the interesting features about mediation. And for those, I think that should encourage other people to also consider arbitration as mediation as a way of resolving their disputes. Yes. So the other feature about mediation is that it's time constrained. Other than court processes, which take sometimes a year or even more than a year or even longer periods in some circumstances. When it comes to mediation, the rules that govern mediation constrain the period within which the solution is supposed to be reached or the mediation is supposed to be concluded. The mediation, according to those rules, is supposed to be concluded within 60 days, which is roughly 2 months. So you realize that a solution is reached within 60 days. In case these 60 days elapse and the parties think they are still, they are moving towards reaching an amicable resolution, but maybe they have been constrained by the 60 days, you can actually ask for an extension of time in court and it will be granted to you. So the rules provide that in case the 60 days expire, the parties have an allowance of 10 more days through which they can, or in which they can have their dispute or their mediation conducted to see that they reach an amicable resolution of that matter. Who meets the costs during mediation? Who meets the costs of the parties? Because when parties go to court, there is usually an issue of costs that arises. In court, they say costs follow the event. After the judge making a decision, one of the parties or both of the parties will pay costs in certain circumstances. In mediation, both the parties meet their own costs, so each party caters for their own costs. You will not find in mediation the mediator or the parties saying, okay, we have gone for mediation, but I'm not going to incur the cost, it will be you to incur the cost. That may only arise on the agreement of the parties. However, in mediation, each party bears their own costs. The other question would be who pays the mediator. So in our court annex mediation, where I mentioned a certain category of people who conduct the mediation as the judicial officers or someone who has been accredited by that particular court or the Center for Arbitration and Dispute Resolution to be a mediator, the costs shall be paid by the court itself, or the mediator shall be paid by that court itself instead of the parties. The parties may only pay the costs for the mediation or for the mediator if they agree and bring in someone else who is not a judicial officer to conduct their mediation. That's the only circumstance under which the parties may have to pay the mediator. Otherwise, the mediator will be paid by the court itself. So one would be there saying, okay, you have convinced us about this entire process called mediation, but how is it conducted in courts of law? So mediation is conducted in a very, very simple way, like I'm going to try and elaborate. So when you go to court, you're going to find, you can make inquiries from anyone that you get at court. However, there's usually a registry, a mediation registry, which is put there specifically to handle mediation cases. So at this mediation registry, you're going to file a document for your mediation, which is your mediation case summary. This mediation case summary is going to have the name of that court, which is going to conduct the mediation, the name of the parties which are disputing. It will have space for the number of that mediation according to the court registry, where the court staff will help you fill in the number. And then it will also include in that mediation case summary the brief facts of your case, or the brief facts of your dispute and how it arose. In that same document, it's encouraged that you put the laws on which you're going to rely on, if any. You're going to also include the parties who are going to be involved in the mediation, the witnesses, if any, who will be involved in that mediation, the documents or documentary evidence that you wish to rely on in that mediation. The other segments that you're going to include in that mediation case summary are the lead negotiator, who is going to help you to negotiate during this mediation process. And the other one is the person with the authority to sign an agreement which will be reached after this mediation has taken place. It's also encouraged that you put your proposal at the end of all that. Put the proposal. What do you want the mediation to end in? What is your proposition that you want the other party to consider? So you prepare a document with those few details, present it at the mediation registry at the court. The person there will register that mediation of yours and give you a particular number for reference for which you're going to use. And then they will give back copies of that document to you. One document will be yours, and then the other one has to be served upon the other party with whom you are disputing. When you serve this document on the other party is also supposed to prepare their mediation case summary. In their mediation case summary, they'll put the same information that you put in your mediation case summary. However, they'll put according to what is in their case. So they'll also put the name of the parties. They'll put the name of the particular court which is going to resolve or which is going to hear the mediation. They'll have the mediation case number, because at that point the mediation case number has already been issued by the court. They'll have the brief facts of the case according to them. It may be exactly what you've put in your case, or it may be slightly different from what you've put, or even completely different, but they'll have their brief facts of their case. They'll also mention their lead negotiator. It could be them themselves or any other person who they want to assist them in negotiating. They'll have the name of the person who has signed the likely outcome of the mediation or the resolution from the mediation. And they will also put the name of the witnesses who they want to be present during the mediation, and the laws or even the evidence, the documents that they wish to rely on during their mediation. When you present those two documents to court, when both parties have presented those two documents to court, the mediator will issue a mediation hearing notice. The mediator will find the most suitable date for determining that mediation, and they will issue a mediation hearing notice, which will entail the name of the court, the parties, and a specific time, a specific date, and a specific place where this mediation and when this mediation is going to take place. That mediation case, the mediation hearing notice will be served upon the parties by the court process server, informing the parties of that date. On that date, the mediator will meet the parties in a very neutral ground where their confidentiality can be maintained and where it's only the parties who are disputing. The mediator will facilitate communication between these two parties who are who are disputing in a bid to see that these two parties reach an amicable resolution to their dispute. At the end of such an arrangement or such a sitting, the parties could reach a resolution which should be put down by the mediator in writing, and the parties should sign on the same. This resolution shall be then be taken to the court as a consent judgment, and it shall be endorsed and signed by the judicial officer, and it shall have the same effect as a judgment of court. The orders shall have the same effect as court orders. In the other case, the parties may agree also to come back for mediation on another day. They may not agree on a solution on that day, but they could agree and say, okay, today let's end here, but we shall continue with our mediation on such and such a day. And then in case the parties explore all these means and they fail to come up with a solution through their mediation, that case shall be taken to the courts of law before a judicial officer who shall hear this case and issue a decision for these parties here. So no, people should not get scared and say, okay, you're encouraging us to go and do mediation, but if our mediation fails and yet we didn't go to courts of law, then I will end up losing everything. No, if your mediation fails, this same matter that you took to mediation and you didn't reach a solution, you can still go ahead and present this mediation to the courts of law, and the courts of law will determine it. I think the other thing which would arise, someone would be wondering, okay, you have told us about confidentiality and all that, but you're saying after we have failed to agree during mediation, the matter can then be taken to the courts of law. Can this same judge or judicial officer who you said can do mediation, can that same judicial officer, the judge or registrar or magistrate, hear and determine that same issue now in the courts of law? The answer is no. The mediation rules of Uganda provide that in case a judicial officer handled a matter during mediation and that mediation was unsuccessful, that same judicial officer cannot go ahead and hear that matter in the courts of law, in the formal court processes. So you will be rest assured that if the judicial officer had your case and it wasn't successful in mediation, that same judicial officer is not going to be the one to hear it in case it proceeds for formal court hearing. Briefly, that is what mediation is, and I'm confident that from my explanation you've seen that it actually has certain features which make it very unique, but also very easy to use, and it provides a very quick solution for you. So you should actually consider mediation as one of your ways of resolving disputes. The other dispute resolution mechanism is arbitration. Like I said in the start, there are several days: mediation, conciliation, arbitration, negotiation, early neutral evaluation. Today we are also going to talk about arbitration, briefly what it entails and why you should consider arbitration as a means of resolving your disputes which may arise. So just like that, you'll have your dispute processed through mediation. You come up with a solution. The solution wasn't given by a judicial officer, it was given by the parties themselves, and it took only 60 days or a maximum of 70 days for you to arrive at that decision. And so you'll have gotten a resolution by the parties themselves, and the parties will go away both satisfied that they have gotten justice through the mediation court procedure instead of having gone through the normal court processes. So that's briefly what mediation is about. And so I'm going to also talk about arbitration, which is one of the other mechanisms we said of alternative dispute resolution. So of course, the first thing that one would want to know about arbitration is what exactly is arbitration. For mediation, you said a neutral third party facilitates the parties to reach their own amicable resolution of a dispute. So how about arbitration? What happens in arbitration? So in arbitration, the parties actually decide to take their dispute to another neutral third party. And this time around in arbitration, the neutral third party is the one who provides the resolution to the dispute for the parties. So the parties accept or agree to bring this dispute to someone who they trust is knowledgeable in that particular field where the dispute has arisen, and this particular person who is also experienced and qualified to do arbitration will issue these parties a resolution which is referred to as an award. What are the types of arbitration? So arbitration can be international or domestic. What is domestic arbitration? Domestic arbitration is where the parties, for instance, are doing business in a particular country, say in Uganda. The dispute has, say, arisen in Uganda, and these parties have agreed to do their arbitration process in Uganda and using the laws of Uganda. That's domestic arbitration. International arbitration is now the complete opposite of the domestic arbitration. For international arbitration, the parties could be doing their business in Uganda. Maybe the dispute has even arisen in Uganda, or will arise in Uganda in any case, since that's where they're carrying out their business. And the parties agree that in case a dispute arose, they want their arbitration to be carried out or the process to be conducted in another country and using the laws of another country. So in arbitration, it's possible that you can do your business in Uganda and you want the laws to govern your arbitration to be the laws of Kenya, and your arbitration to actually be conducted in Kenya. You see how flexible that is compared to the normal court processes. So arbitration also has certain features which make it unique. The first one is the arbitration agreement. There has to be an arbitration agreement for there to be arbitration in the first place. In case the parties didn't agree previously to bring their dispute to arbitration, then there is no arbitration that is going to be conducted. So for arbitration, it arises when the parties are actually entering a transaction or a contract, or where the dispute has arisen. These parties then agree that in case a dispute arises out of this transaction, instead of going to courts of law, we are going to take this dispute to arbitration and to be resolved by an arbitrator. So the agreement can be as simple as one sentence. It doesn't have to be, 3 pages or very many words. It can be as simple as one sentence. If the parties are entering a transaction and they are drafting their agreement, you can just put one clause on dispute resolution and say, in case a dispute arose out of this transaction, the same shall be referred to arbitration. And that is it. That agreement suffices. It's a good arbitration agreement. The other way that some people do that is they come up with a whole agreement, an entire agreement, and mention the terms by which this arbitration is going to be conducted. I'll talk about that a little bit later in a bit of detail. The other feature of arbitration is separability. In arbitration, when the parties agree that their dispute is going to be resolved through arbitration, and they have that simple clause, like I've said in their agreement, that in case a dispute arose, the dispute shall be resolved through arbitration. That particular clause, even if it's 1 line or 2 lines or 3 lines, is considered as an agreement on its own. It's not part of the other transaction of the agreement that you're making for the transaction. So you notice that even when this other agreement that you made for this other transaction is considered to be, say, illegal, or you've breached it, or it's null and void, it doesn't in any way have any effect on this arbitration agreement. These 2 lines or 1 line that you've written, that your matter is going to be referred to arbitration. The other one is the other feature is the competence feature. The competence feature is also a very interesting one. It entails the fact that in case one of the parties was disputing the jurisdiction of arbitration and said, no, maybe we didn't agree to go for arbitration, or we don't have any agreement to that effect that this matter is supposed to be taken for arbitration, it's an arbitration tribunal that resolves whether they have the jurisdiction to resolve that dispute or not. In case there is something that indicates that the parties may have accepted to go for arbitration, you don't take that dispute to courts of law to decide for you whether the arbitration tribunal has jurisdiction or not. It's the same tribunal that sits and says, okay, we have had this objection to our jurisdiction. and yes, the truth is we don't have the jurisdiction, so go to court. Or they decide and say, yes, we have listened to this objection to our jurisdiction, but we have decided, according to the facts before us, that we actually have the jurisdiction because the parties accepted to come for arbitration. Yes, that is the other feature of arbitration, and which makes it very unique. One would wonder, who chooses this person to be the arbitrator? Because in mediation, you said the mediator can be a certain group of people, the judicial officer or someone who has been accredited. So in arbitration as well, the parties decide who is going to be the arbitrator. Of course, it should be someone who is qualified to be an arbitrator, but no one decides for you who among the 1,000 or 100. The parties themselves sit and say, okay, a dispute has arisen. We want it to be resolved through arbitration, but we prefer Wandera to be our arbitrator. No one else is going to take that dispute away from Wandera's hands to resolve if the parties have agreed to have it resolved by Wandera. I want to also talk to us about the arbitration agreement. Briefly, like I said, the arbitration agreement has to be in place for an arbitration to take place. Arbitration agreement is simply an agreement by the parties to refer any dispute that may arise or a dispute that has even already arisen to arbitration. And like I said, the arbitration agreement can be as simple as it can be. It can be one line, it can be 2 lines, or it can even be a couple of pages, depending on what the parties are comfortable with and how well they can put it down. And the parties should have signed on this agreement. The agreement has to be in writing. In arbitration, the agreement has to be in writing. It's the only way you can satisfy someone later on if a dispute has arisen that you actually agree to go for arbitration. So the point that I'm trying to push home is an oral agreement will not suffice in arbitration. So you have to make sure that agreement has been put in writing, because later on, one of the parties may deny to have agreed to go for arbitration. How do you prove that they actually agreed? You can only prove if you actually put it in writing that if a dispute arose or for the dispute that has arisen, the same shall be referred to arbitration. And then there are situations where, because people are used to the normal court processes, a dispute has arisen between the parties, and the first thing they do is to run to the courts of law. They file the matter in the court and it's already before the formal court procedure. What do you do in case such a matter or such a situation arises and yet you already decided to have your matter go through arbitration? The party that actually wants their matter to go for arbitration in such a situation is supposed to inform the judge or the registrar or any other judicial officer before whom this dispute has been brought in the formal court processes. You make an application to that court, inform them that this dispute is actually supposed to be resolved through arbitration because the parties agreed that it should be resolved through arbitration. There is no judicial officer, after satisfying them that you signed an agreement and agreed that the dispute will be resolved through arbitration, there is no judicial officer who will go ahead to hear such a matter. There and then, they will halt the proceedings and refer you to arbitration because they will not have the jurisdiction to determine such a matter. And then if the parties are already having an arbitration, they are before the arbitration tribunal, but then they still think they can sit together and maybe come up with a resolution. Is that possible? Or does that mean that when the matter is before arbitration, then you can't resolve it outside that arbitration? So even with arbitration, you can still resolve your matter outside the arbitration as the two parties. You can, even when the matter is before the arbitrator, you can go back home, you agree and say, okay, I wronged you in such and such a place, you are right here, we can agree and come up with a solution and resolve our dispute this way. And then you go back to the arbitrator, inform him that we sat down and this is what we agreed, and that's what the arbitrator will issue as his award without deviating from it, if that's what the parties agree to go by. For arbitration, it also has certain awards, types of awards that the arbitrator may issue. Just like the courts of law have different orders that they may issue, even in arbitration, there are different awards that can be issued by the arbitration tribunal. One of the awards that the tribunal may issue is the interim award. The interim award arises where a certain matter arises before the entire dispute is determined. That matter is heard by the tribunal on an interim basis, and they issue an award. That doesn't mean they have resolved the entire matter, but there's something that arose in between while they were determining the entire matter, which they needed to make a decision or a stand on. That could, for instance, be the jurisdiction. In case the matter is already before the arbitral tribunal, but one of the parties is disputing the jurisdiction of that court, the court will listen to both parties' arguments to determine the facts and come up with an interim award only on the jurisdiction before they listen to the other entire matter. The other example also could be the laws that govern the arbitration or the seat of the arbitration. The parties could already be before an arbitration tribunal. However, one of the parties disputes the laws which are being used. He says, maybe we agreed that we shall be using the laws of Uganda, and that's where our seat of arbitration shall be. While the other party would be saying, maybe we agreed that our seat of arbitration shall be Kenya, and we shall be using the laws of Kenya. So in such a situation, the arbitration tribunal will listen to only matters to do with which law is governing that arbitration, and they will issue an award on specifically that particular matter. And that is one example of an interim award. The other one could be a consent award, the other type of award that the arbitration tribunal could issue. The consent award, like the word consent itself entails, is an amicable agreement between the parties. A dispute has arisen, it's before the arbitration tribunal, but the parties go back home outside the arbitration and reach an agreement on how they want to go ahead with their transaction, or how they want the dispute to be resolved. In such a situation, the parties agree on the terms by which they want to move forward. They'll bring these terms to the arbitration tribunal, and the arbitration tribunal shall issue a consent award by the consent of the parties, and it shall have effect as good as any other award of the tribunal. The other one is a default award. A default award arises where one of the parties in the arbitration does not attend the arbitration proceedings. They have been notified, but in default, they do not attend the proceedings intentionally. The arbitration tribunal will go ahead to listen to this party that has complied and has attended the arbitration. They shall evaluate the evidence, although the other party was around, but then they shall issue a default award because one of the parties defaulted to attend the arbitration proceedings. And then the most common is the final award of the arbitration tribunal. The final award usually arises where the dispute has been brought before the arbitration tribunal. The arbitration tribunal has determined the dispute. It has listened to both parties and has come up with its own decision on the dispute. The arbitration tribunal will then issue a final award. The final award extinguishes all the proceedings of arbitration because it sums up the decision for the entire case. So those are some of the awards which could be issued by an arbitration tribunal. One would wonder, is the award then enforceable immediately that it's issued by an arbitration tribunal? Once the award has been granted by an arbitration tribunal, since an arbitration tribunal is not a court, that award has to be taken by one of the parties. It's most especially the successful party. Take that award to the court and apply for it to be recognized. Once that award has been awarded by the tribunal, you take it to the court, make an application for it to be recognized. All you have to present to the court is that award itself, which has been issued by the arbitration tribunal, and then the agreement, the arbitration agreement that we talked about, or agreement to arbitrate. If you don't have them in the authentic copies, at least bring a certified copy of them. Present them to the judicial officer in the court. The judicial officer is going to pronounce that they recognize such an award in the court, and then you can enforce it the same way you'd enforce any other order of the court. In most cases, the party who has lost in the arbitration is very willing to satisfy their part of the court order. So you don't, there is no pulling ropes after that you have to employ, court bailiffs, and then they will issue notices and sell people's property. In most cases, you realize that after alternative dispute resolution, the party who has lost usually is quick to satisfy the court order the way it has been made. So briefly, that is what arbitration is. So today we have talked about mediation and arbitration. I hope we have been able to understand what the two entail and the features of both of them, and how the same can actually be employed in resolving disputes that may arise between people. While I was introducing the topic, I said at the end of the topic, I'll also talk about the advantages of this alternative dispute resolution. One would wonder, okay, yes, you've talked about all those, but why should we consider those ADR mechanisms instead of taking our matters to the courts of law? So these are some of the advantages of alternative dispute resolution, which may convince you to consider alternative dispute resolution other than going to the formal court processes. The first one is control. In alternative dispute resolution, the parties have control over the entire proceedings. Like I've just mentioned, in arbitration, the parties can decide who the arbitrator is going to be. They can decide when they want to sit for the arbitration, and they can even decide where they want to sit for the arbitration. So it's in the control of the parties, other than the normal court processes where the dispute is taken to a judicial to the court, and the court decides for you which judicial officer is going to listen to the dispute and come and make a decision. The other one is that it saves time. Like I said about mediation, for instance, mediation takes only 60 days according to the rules. In case the parties want more time, there is an addition of only 10 days to make 70 days. So you realize in a period of about 2 months, the parties have actually reached a decision, compared to courts which may take a year or even more than a year. The other thing is that it's confidential. Alternative dispute resolution is confidential. Like I said when I was talking about mediation, the parties meet with only that neutral third party. So it's only the disputing parties and the neutral third party. So whatever they discuss is between those three people, the mediator, and the two disputing parties. So that information is never taken to the public. And yet in courts, your case may be called in the open courtroom, and it will be determined in the presence of the entire public. So the entire public will go away knowing how you met and what you did and how you're a very bad person, which is not the same with alternative dispute resolution. The other thing is alternative dispute resolution is flexible. Like I explained about arbitration and mediation. In mediation, the parties decide when they want to sit. In arbitration, the parties also decide where they want to have the arbitration. The parties decide even which laws they want to govern their dispute. The parties decide who should be their arbitrator, which is not the same with the courts of law. In the courts of law, it's the court that decides for you all those, because they have to make sure that there's no bias. Yet in arbitration, the two parties actually decide how the dispute is supposed to be or is going to be resolved. The other thing is that it saves money. Alternative dispute resolution saves a lot of money. When you go to court, you may be required to pay court fees. You're encouraged to have a lawyer to offer you legal advice and represent you in court. In alternative dispute resolution, you don't need a lawyer. You only need yourself, the disputing parties, and the person who is going to resolve the dispute for you. So you realize that you save a lot of money as compared to the normal court processes. And like I said, alternative dispute resolution could even take just 1 day and you'll be with your resolution or solution. And yet court processes, there's no court process that will take for you 1 day. You'll go there at least more than once for you to come up with a decision. So you realize that it even cuts on transport costs. You will not have to go to court every other day. The other thing is that alternative dispute resolution usually maintains the relationship between the parties. You realize that these two parties are the ones who agree to either go for mediation or arbitration or another form of alternative dispute resolution. So, and at the end of the day, the two parties are the ones who agree the decision that is going to be taken upon their dispute. So you realize that both parties will shake hands at the end of the day because they both agreed on the resolution of the dispute and the solution that is going to be given by the mediator, or even the solution that is going to be given by the court. So the relationship between the parties is maintained. The other thing is it gives a win-win solution to the dispute. Other than court, where you bring your dispute to a judicial officer, the judicial officer in most cases will pronounce that one of the parties is right and the other one is wrong. In alternative dispute resolution, you realize that both parties will go away happy because they reached an amicable resolution. They reached a middle ground which favors both of them. So both parties will go away with a win-win situation, as compared to courts where one party will be successful and the other one will have lost. And then quick access to justice. Like I've said throughout my presentation, in alternative dispute resolution, the parties reach their resolution quicker than they would if they had gone through the formal court processes. So those are some of the advantages that alternative dispute resolution has, mostly over the formal court processes. And that's why I encourage all of us, in case a dispute arises, don't be in a rush to take it before the courts of law. Courts of law are a good place for you to take your dispute, but you can actually resolve these disputes by yourselves or using other means of dispute resolution, like I said previously, mediation, arbitration, conciliation. It could even just be negotiation between the parties, and you come up with a resolution to your dispute. So that has been our presentation today about alternative dispute resolution. I want to also call upon you to subscribe to our channel, the Judicial Service Commission, Uganda, for such educative material. In case you like this video, you can also go ahead and hit the like button at the bottom. In case you have any questions, put them in the comment section. In case you have suggestions of some laws that you want us to discuss for you, that you want us to elaborate for you, don't hesitate. Go ahead and put it in the comment section. That has been our presentation today. Bye.